Hello, I'm Dr. Daria Sharkova, and today we have the 11th webinar of our series, Houston, We Have a Solution, this time with Denton Nichols, partner at International Arbitration Practice of Norton Rose Fulbright. Today we will discuss the impact of AI on international, 10 predictions that Denton has on the impact of AI on international arbitration. And as usual, we will first ask Denton how he ended up in Houston.
Wow. So first of all, thank you, Daria, for the invitation, and hello to all the viewers out there. How did I first end up in Houston? I actually ended up here first for undergraduate. So I went to Rice University for the first 4 years after I graduated high school, graduated from Rice, and had a wonderful time at the university and really enjoyed my time in the city. Though if I'm being perfectly honest, I didn't really think I would necessarily come back to Houston or Texas. I'm not a native Texan. I grew up in Seattle, Washington. So after university, I went to Chicago, where I did some consulting work for a year while I applied to different law schools and postgraduate programs. I ended up choosing to go to the University of Texas, where they have a dual degree program, or they did at the time, I think they still do, JD and a master's in Latin American studies. So that's a 4-year program. So that's what brought me back to Texas. And then actually what brought me to Houston is actually one of your prior guests, Judge Michael Massengale, who at the time was still a justice on the First Court of Appeals here in Houston. And he graciously extended me an offer to be his law clerk after law school. So that was a wonderful opportunity, learning the law under him and getting to see the law from sort of the judge's side. And it's wonderful training anyways. I always recommend that law students seriously consider taking a clerkship after law school. But in any event, that's what brought me back to Houston. And after my time at the First Court of Appeals, I ended up at my previous firm where I practiced broadly in commercial litigation for about 2 years. But I always wanted to do something a little more specialized, something that leveraged my international background, that leveraged my languages. So I should mention that I have a particular love for languages.
We share.
Yes, absolutely. We both share that. And I speak, in addition to English, Spanish, French, and Portuguese. And I have lived, studied, and interned in countries that speak all of those languages all the way through university and into law school. And I kind of thought I wanted to do something with that background. And international arbitration, what's so interesting about it is that it sits at the intersection. It's a disputes practice, but it's uniquely focused on international affairs, international law, conflicts of law. And I find that all very interesting. So I heard about an opportunity to join the international arbitration team here at Norton Rose Fulbright. That was in 2015. I made the move over as a lateral, kind of a mid-level associate, and I learned from partners on that team and learned my craft here at the firm. And I've been here now for 11 years. So
Happily ever after.
Happily ever after, I hope so. I hope to remain here for the rest of my career.
Great. So not only we have a very intriguing topic today, but I have a lot less job this time because Denton has already sent me all his predictions. So we will just discuss them one by one. So first prediction is that going forward, everyone participating in international arbitration will only increase their use of AI.
Yes. And of all my predictions today, this is probably going to be the easiest because
That's true.
I think everyone is going to be increasing their use of AI. So in my practice, I almost always wear the hat of counsel representing parties in arbitration. And let me say that even though I am relatively new to AI tools, having really picked them up really about the beginning of this year, I can already see the tremendous impact and potential that they have. And I have integrated them into my day-to-day practice. So have others at my firm and others on my team. You know, as counsel, they really help us do heavy lifts. in a number of ways. I think AI, although some people may disagree with me, actually does a fairly good job at first drafts, particularly of simpler documents like letters, correspondence, or kind of routine sections of a brief, for instance. So that really can accelerate the drafting process. I think it's an excellent editor. It picks up not just on typographical errors and issues of consistency, but it can even suggest ways of improving your language, of making your point bolder or more persuasive. And I've actually found it to be a very good editor in that respect. It's excellent at doing searches through documents to find key information or key facts, so you don't have to just go through it all yourself or have an associate do it. It's also very good at synthesizing and summarizing. You have a large volume of documents. So if you want to come up with like chronologies, or what we often call in arbitration, the dramatis personae, who are the main actors here, you can just upload a batch of documents and emails, and it'll tell you all the different individuals and kind of key roles on a particular matter. AI is also not bad at being kind of a critical eye for your arguments. You can take a draft brief, for instance, put it through the AI system and say, how would you respond to this? And if you were on the other side, and it will come up with angles perhaps you haven't thought of, maybe gaps in the arguments, and you can look to close those gaps. So it helps you kind of improve what you're doing kind of as a sounding board. It's good with witness preparation. You can take notes as you're going. For instance, if you're on Zoom, like we are here today, you can record the text and then create a summary of that. You can come up with first drafts and witness statements. You upload documents and interview notes. And so it can help in a number of ways. The best thing, though, and I think all the practitioners will cheer for this, Redford schedules, coming up with document requests and responding to document requests. That is the bane of every international arbitration practitioner's practice, is going through those, because they're so rote, they're so dry. And I find even myself with trying to concentrate on those when they turn to like 50 or 70 pages long, it's very hard to do. AI does not fatigue them. It'll go through everything. It'll check your arguments for why something's relevant material against the record, come up with great citations, and come up with potential responses. Somebody else's document request. So there's a number of other ways. I'm not, for the sake of time, I'm not going to go through all of them, but as counsel, I think I've just given a taste of how useful it can be. I think it's helpful for parties as well. Oftentimes we'll send our client a big submission that was just entered, and instead of the client having to go through all that, many of them I know are putting it through AI to come up with succinct summaries, and to understand what has the other side said, which means that they can report upward into others in their organization faster. What's going on in the case. And I also know that parties are using them for case evaluation. You can upload the briefs on both sides and ask the AI, what are the main issues in dispute? Who do you think has the stronger argument here? I would not rely on AI to do a full case assessment, but I think it is a nice sort of sanity check to understand what's going on. So it helps parties keep tabs on what's going on.
A little bit provocative questions we didn't discuss in advance.
I love it.
Do you think it's a threat for the junior associates?
Oh, great question. Is it a threat for junior associates? Certainly, I think it is replacing much of the time that junior associates would otherwise spend, for instance, going through documents, summarizing, coming up with first drafts of letters and pleadings. So I have, if I'm being honest, for those kinds of tasks, I'm relying less on junior associates. But I think it's also an opportunity for junior associates. If you can get really good at AI and these tools, then you're going to move up that value chain all the faster. And so I would tell any junior associate, get really, really good at this, and make sure that others on your team, particularly more, if I'm allowed to say this, more senior partners or less adaptable to the technology, they will look to you to navigate this new world. And they will think you're just brilliant if you can come to them with a first draft, in a day, whereas perhaps in the past for certain things might take a full week. So I think it's a great opportunity. But certainly I can already see how we're economizing time with junior associates. Sure.
That's right. Prediction number 2,
Mhm.
AI will enable significant but not dramatic savings of time and cost.
Sure. So why do I say I think there will be a cost savings, which will be passed on, I think, ultimately to the users of arbitration, who are the ones who bear the cost. I think they'll be significant, but not dramatic. So let me explain what I mean by that. My first observation is that in legal practice, time is cost most of the time, because we are usually charging by the hour. Even if we have some sort of alternative fee arrangement, implicit in that is some sort of time built in, and we're trying to calculate with the client, what is the value, equivalent value of that time in terms of attorney hours or professional hours. So time is cost. So anything that reduces and shortens the time to do something, I think in the end will reduce costs and redound to the client's benefit. I'll say a few things, a few limitations on that. I don't think the cost savings are going to be quite as dramatic as maybe some clients might hope and wish. There's a few reasons for that. One is a lot of the tasks that we do on a case are what I would call real-time activities, things that we're doing in the moment, like us speaking here today. That includes things like client interaction, client updates, internal strategy meetings, when you have to talk to witnesses and experts, reviewing the other side's pleadings, or reviewing orders or interim awards of the arbitrator, attendance at hearings. There's just a number of things that we do that are actually real-time tasks that AI just can't simply compress. They may assist you in doing those tasks in a number of ways, but we're not necessarily going to shorten the time of those things. So that always has to be kept in mind. The other reason I say the cost savings will not be as dramatic is, remember what I said earlier about moving up the value chain and becoming potentially more productive with AI? Well, just as I can use all these tools to save time and start devoting it elsewhere, so can my opponent. So whereas, my opponent might have only had time to include maybe 3 arguments in a particular brief, maybe they can expand that to 5, 7, or potentially more, because the AI systems can suggest and help you draft more arguments, more requests for production, more detailed responses to your requests for production, more correspondence, challenging your production, a lot of it's around production. That's where we spend a lot of time as counsel, or more correspondence to the tribunal that has to be responded to. So just as freeing up all that time sometimes gets filled by more tasks, and if my opponent's doing that, then I have to respond to that. So there can be an expansion of the amount of activities that we're doing in a case as a result of AI, which will cut against the time savings. Even though each task is maybe taking less time and more economical, in the aggregate, we might actually be doing more in the life cycle of the
And I've
case.
noticed that impact also on the arbitral awards. Because if you look at the arbitral awards 10 years ago, they were 150 pages max. The latest Chevron award, more than 1,000 pages. I guess it's also due to the facility the AI gives for drafting the procedural sections are becoming so huge. And I have a question on this second prediction. Do you think that some clients, not all, will use this AI argument to aggressively try to cut the times?
I think the smart clients will.
Smart.
and they should. Look, they're entitled to get good value for the work that we do. I'll be the first to say that. And so we have to be responsive and adaptive as service providers, make sure that we're providing them that value. And there's already a lot of talk. I don't see quite as much implementation yet, but a lot of talk about increasing use of alternative fee arrangements so that you can get more cap fees or kind of like a menu option, for instance. If we need to drop a brief that's 50 pages, it'll cost this much. If we need to drop a letter, it'll cost this much. So I think we're going to end up having more more alternative fee arrangements as a result. That's what we're predicting here at my firm, and I've heard that from other people in the industry as well.
Makes sense. Prediction number 3. The volume of international arbitrations will grow significantly, but not dramatically, also due to AI.
Yeah, so
interesting.
Here's another sort of significant growth, but not dramatic. Sort of with the cost savings, significant cost savings, but not dramatic. So why do I say it? So let me first say I think there's going to be at least 2 reasons for why AI will contribute to at least some growth in the international caseload. The first reason is sort of obvious, but if AI is a cost savings, which means is also a money savings, then some of those kind of, I'll call more marginal, economically marginal cases suddenly go from perhaps not economic to bring to economic to bring. And so I think we'll see more mid-size and smaller arbitrations where the barrier to entry because of the inherent cost in arbitration might have been judged too high. Those are going to be mitigated, at least to some extent. And so you'll have some more cases as a result. I think that's a fairly straightforward reason that we might see more. But as I mentioned, there's at least 2 reasons. I have a second reason, and this one is one I've more kind of thought to myself. I haven't heard anyone say this yet. But I think you'll have clients conducting a lot more AI-powered case assessments of their disputes, which may cause many of them to be more confident in bringing a claim.
That's an interesting argument.
Right. And so, because that's one of the things you do in a cost analysis. It's not just how much am I going to pay on this case? What is my probability of success? And that coming up with a probability of success has historically been very difficult. There's not a great sort of database. Well, now there are, but historically there haven't been great databases of international arbitration awards to compare against. And it also, I think clients sometimes hesitate to rely on their counsel's assessment of case, particularly as a claimant, because they think, I'm always going to tell you have a great case because I want the work. I assure you, I always give very objective analyses, but now you can test your counsel's assessment of the case against something that feels objective, which is AI. And so if clients are becoming more confident about bringing cases and they believe that the cost of that case is potentially going to be mitigated because of the AI tools, then I think you are going to see more cases. But as I said at the beginning, although I am expecting some increase, I don't think it will be as dramatic in international arbitration as perhaps in other kinds of disputes, particularly domestically. And I think the reason for that is there is sort of an upper limiting factor on international arbitration that you don't have in other areas of law, which is namely you can't bring international arbitration unless you have contract with an international arbitration clause, right? That limits inherently the universe of potential cases that can be brought and parties that can be brought into arbitration, sort of like a natural upper limit. Whereas in other areas of law, such as consumer disputes, employer disputes, I think there's less of that natural limit, and we are nowhere near close to that. So that's why I think other areas of disputes work may have a greater explosion of cases, particularly pro se cases and things like that. But I think for international arbitration practitioners, just having that kind of natural ceiling is going to limit how many more cases there are. I'll say in talking to clients, the limiting factor on bringing an international arbitration is not, gee, there's not enough time in the day. It's just that there's just not enough disputes, right? Now, when they go, and they can be very serious and time consuming. But there is that sort of natural ceiling in our field that doesn't exist elsewhere.
That's right. So prediction number 4, I like this one. AI will enable arbitration proceedings to become truly multilingual.
So why do I say that? So I think many of the people attending probably already know this, but we have a concept in international arbitration of the language of the proceedings, right? And that is the common language that everyone has agreed to use for receiving arguments, for making the record, eventually making the award of the arbitrators. why do we have that? There's a few reasons, but largely it's simply just a matter of convenience and procedural efficiency, because we don't want to have what I call the Tower of Babel scenario, where everyone's just speaking a different language and we need translators all the time. And that can get very messy. And so we kind of agree, because we understand that international arbitration may touch on people from different linguistic backgrounds, that we need to have one language here, guys, when we're coming together to resolve our disputes. Now, in practice, what that has meant is that it has forced essentially monolingual arbitrations, and English is particularly dominant. I went before this talk and got some statistics. If you look at different international arbitration institutions, the lowest percentage of English as the language of the proceeding cases is 50%. That's the Stockholm Labor Chamber of Commerce, all the way up to 95% for the London Court of International Arbitration. You know what it is for the ICC? 80%.
80%.
That actually surprised me. I thought it would be much lower, given it has, it touches a lot more jurisdictions than just English speaking ones.
My experience at the ACC, English is still predominant. Even French is not that important.
So it would not have surprised Daria, but it actually surprised me how dominant that was. No, I love that. Love that. So what does it mean, though? What does AI's introduction mean into this process? Well, first of all, AI, translation and interpretation of language is the ideal use case for AI, because you're taking natural language and converting it into another natural language. That's what large language models, LLMs, do especially well. They can make almost instantaneous translations of briefs, documents. Here on our Zoom call, I bet anyone can click a button and translate my speech and your speech into whatever language, Arabic, for instance, whatever language they prefer, almost instantly. And all these technologies, I think, are going to be leveraged and are being leveraged in international arbitration. So we're entering into the possibility of what I call the Star Trek universe. If you've ever seen Star Trek, you ever notice like people come from, well, think about this. People come from different planets that have completely different languages, and yet everyone seems to understand each other. That's because there's this idea, there's a universal translator that you're like wearing on you. And so that's why everyone can understand each other.
Like a chip in your brain.
Kind of like that. I'll think usually it's like the badge, that they wear. Sorry, I'm coming off as a bit of a nerd right now. But think, I don't know that we'll have that Star Trek badge necessarily, but it means that the need to have a single language as the language of the proceedings is less necessary, where everyone can translate things almost instantaneously. If you have a good audio sound, you can put it into a translator that almost instantaneously translates somebody's words into text that you can read. And so I think that the possibility of us coming together from different language backgrounds and speaking to one another in our natural language will become all the much easier. We probably still will have a language of the proceedings, but I think the tolerance level for accepting submissions and evidence in other languages will go up, and even arguments and witness testimony, I think, will also go up because these tools are just so useful.
That's a great prediction. And the next prediction is that the counsel representing parties in international arbitration will also become more diverse.
Yeah.
I like this one.
Yeah, no, I do too. And let me explain what I mean by that. There's different ways in which counsel will become more diverse. And I think the first kind of, I'll call it the primary way, is I think we're going to see more geographic diversity of counsel, and more counsel, more lawyers who are themselves not necessarily specialists or experts in international arbitration.
You can
handling. Yes, and let me explain why. So before getting there, I think we should know kind of where we are now and historically, that counsel in international arbitration has historically been dominated by firms from English-speaking countries, particularly the United States and the United Kingdom. Largely, again, that goes back to the language of the proceedings. It's also a reflection of the fact that many international contracts borrow or apply U.S. laws, the law or English law. And so just kind of naturally,
Mhm.
law firms in those jurisdictions have had an advantage. But we've seen over the years, even before AI, the rise of boutique firms,
Mhm.
particularly in other countries, because as kind of international arbitration kind of became the common way everyone resolves global disputes, there became a need to bring foreign trained lawyers such as yourselves into firms. And many of those lawyers, they work at those firms, they practice at firms, and they go back to their home countries and launch their own international arbitration practices. So we've seen the rise of international arbitration boutiques all around the world. Um, we're also seeing a pullback by what we'll call the big law firms from investor state cases in particular, which has nothing to do with AI.
Oh, that's interesting. Why?
Yeah. So I'll get to
Mhm.
why in a moment. There's a law.com article that came out in January this year that had a fascinating statistic that in 3 years, between 2023 and 2025, the number of big law firms involved in ICSID cases fell by 39%.
Mhm.
But the number of ICSID cases overall rose during that time by 15%, which
Mhm.
almost magnifies that drop in participation.
That's right.
But those cases are still being brought, they're still being litigated. Who's picking up the slack? It's smaller firms, mid-sized firms, many firms outside kind of the traditional
Mhm.
international arbitration jurisdictions. I think that's actually a lot of that's economic reasons
Mhm.
that kind of go outside the scope of what I'm talking about today. But personally, I haven't seen, or at least in our firm, we are still very much involved in investor state arbitrations. I have two going on right now. But we have seen something of a retreat of big law firms from that work to some extent. Um, so I think AI is going to accelerate that. Oh, by the way, let me at this point, I
Mhm.
don't see big law firms necessarily retreating from international commercial arbitration. I think they're still very involved there, and that work is still expanding. But I think the AI is going to kind of accelerate the diversification that's already ongoing. As mentioned, the language of the proceedings is less and less important. So if you're a speaker of English as a second language, it's easier to participate than ever in an international arbitration where English is the language, or French is the language, or Spanish, if you're not a speaker of those languages, for all the reasons we just discussed. I also think, and I've seen that AI is actually a really great tool for navigating processes. So let's say you come to an international arbitration for the first time, what do I do? If you're international arbitration practitioner, I go back to a template, a demand for arbitration I've used in the past, and I just use that as my template for the next case. But what if you've never done one before? In the past, it might have been difficult to figure out, well, how do I even present my case? Now you can ask these AI tools, give me a demand for arbitration, and they will. They'll produce it, and they'll produce responses. They'll help you understand what a procedural order is. They can do so much more to kind of educate you, kind of on the job training as you go through a process. So I think that's why, to your question, why do I think we'll see more non-specialists enter the field? Because they'll feel emboldened to do that because of the AI tools.
Oh, I wish it was there when I was at the ACC like 15 years ago, because some of the submissions we couldn't even read. It was in very, very weird English.
Yes. Yes.
We couldn't understand what was going on. That's a great addition, actually. Oh, so next prediction.
Yes.
The value of quality advocacy will be magnified by AI.
Yes. And so this is sort of not quite a counter, but a qualifier to my prior point, that you're going to see more entrance into representing parties as counsel in international arbitration. I think that the value of really knowing the system, of really knowing what an international arbitration is supposed to look like, and being a quality advocate is going to go up. Because one of the questions I'm asking myself in this very interesting moment we're all going through is, what is my value proposition, right? As a specialist. And my answer is that I offer clients high quality advocacy, both written and oral, which is still, I think, going to be the main thing that distinguishes good counsel or decent counsel from really excellent counsel. With written advocacy, as I mentioned before, I think you're going to get a lot longer submissions, particularly by sort of less experienced practitioners. But longer is not necessarily better. If you've ever asked,
Often not even better.
exactly. Well, if you've ever asked an arbitrator, they'll tell you exactly that. That long submissions are not necessarily more persuasive, and they really appreciate ones that are really concise, get to the point, and to the points that really matter. So good counsel is really good at distinguishing what is a good argument, what's a really good fact to focus on, what's a good way to present the order of my arguments, what's a good story to tell that pulls all these diverse data points together into a cohesive case. Good counsel is sort of an artist in that regard and knows how to do that. I think good counsel will actually be putting in shorter briefs, not longer briefs, in this era of AI. The other thing that good counsel does is oral advocacy, because we still have live hearings, usually in most international arbitrations, and those hearing skills are really what sets apart quality counsel. And you have to be able to speak not just to the mind of your arbitrator, but also to the heart.
That's right.
And you also need to really be very good at reading the room constantly, reading the faces of the arbitrators, reading the witness, reading the reactions of opposing counsel. You have to have this kind of situational awareness that people who practice in hearings and go to hearing frequently, like I do and my colleagues do, develop only with time. And so you'll always have an edge because of that experience. And really good counsel also knows how to control the tone, the cadence, the body language, in order to really drive a point home or drive a series of questions and answers home in a way that resonates with an arbitrator. So I think if you're a really good advocate, this will still be a wonderful era in which to practice in international arbitration. I also think AI is going to raise the bar of what looks like a good brief. Because as you mentioned, back in the past when anyone submits anything, there's not a lot of quality control. Everyone's going to be running their briefs through AI.
Which is great.
Which is good because it'll probably increase comprehension, but it only gets you, I think, kind of that level of good, But I think excellent counsel, excellent advocates can take whatever AI produces and make it even better, make it land better. And so that's why I say that the value of quality advocacy is really going to be magnified with this new technology.
That's a great point, though, for the advocates of AI, right? Because sometimes people are still very, very careful and scared, I would say, of AI, some of advocates as well. So the next prediction is the regulatory environment for using AI in international arbitration will become fractured.
This is another, I'll call it easy prediction, because I think the regulatory environment is already very fractured, and actually is rather confusing, difficult to navigate, at least where we are in the present moment. So just to lay out the landscape as of now, different countries and different regions are approaching AI from different standpoints and different priorities. So the EU is looking at AI through the lens of how do we protect fundamental human rights and how do we mitigate risks to people. And so those priorities are really reflected in the EU Artificial Intelligence Act, which goes through different use cases and applications of AI and kind of ranks them based on risk. And they've ranked the administration of justice as a high-risk activity. And there's obligations that attach to that high-risk activity, including that if you were to use AI to prepare rulings or analyze evidence, there's strict data quality standards and logging standards under the Act that, in theory, at least should apply. And so another thing that's interesting about that Act is that, in theory, also, it has extraterritorial application, because even if your arbitration is proceeding outside the EU, if you're going to take an award into the EU, potentially that award and the way it was produced needs to be compliant with the AI, AI Act.
Yeah.
And so it's going to be really interesting to see. I haven't heard yet of a really discrete case where someone has challenged an award based on the way AI was used to produce it or to produce data that ended up in the award. But I think that's something to watch for. But anyways, that's how the EU looks at it. How do we protect people?
Interesting idea for a challenge of award, by the way.
Yeah, it would be.
Maybe we should try it.
It would be, and I haven't thought about this. I wonder how that would interact with the New York Convention standards. Would that be a public policy argument?
I think it may be the public policy.
Yeah,
Or public international.
It could well be. Where other jurisdictions though are looking at differences. So like the UK is really prioritizing innovation because they want to see themselves and their sort of tech firms at kind of the forefront, the vanguard of arbitration, of international artificial intelligence. So the UK's objective is essentially to remain a safe harbor for their tech firms. So what they've done in their 2026 policy framework is to encourage the solicitor's regulation authority to develop its own tailored guidelines for AI, essentially self-policing, a little bit laissez-faire. I mean, there's a chance that the UK government could become more involved, but at least right now, it's a little bit, let's let the actual practitioners develop their own protocols for how AI is used and see what happens. And then you come to the US, which is probably the most fragmented and most sort of conflictive regulatory environment, because what you have right now is this clash between, I'll call it a bottom-up surge of states that are trying to figure out how do we regulate this new technology. And meanwhile, you have right now a federal administration, the presidential administration, which is trying to clear the field for continuing sort of US supremacy in the domain of AI. And so that's really been manifested in an executive order that the president issued that has called on federal legislation to preempt all state laws affecting AI usage that would impose an undue burden on commerce. And in fact, the administration has gone one step further. It's established through the Department of Justice an AI litigation task force. And the DOJ has already intervened in an ongoing lawsuit between XAI and Colorado, because Colorado promulgated its own AI framework law that XAI says is an undue burden, it's constitutionally unvague, and they have other objections. So that the federal government is coming in on the side of XAI, challenging what Colorado is trying to do to regulate AI. So we have this in the hard law area, a lot of fragmentation here in the US, and then you look overseas and there's different rules, different regimes. And so there's a lot of confusion right now. But what's interesting, Daria, is that even though there's a lot of fragmentation at, I'll call it the hard law level, there's actually quite a bit of uniformity, consensus at the soft law level. So a number of arbitral institutions have already promulgated guidelines on use of AI in international arbitration, such as the Chartered Institute of Arbitrators, the Silicon Valley Arbitration Mediation Center, the Stockholm Chamber of Commerce, AAA. All these guidelines, they use different language, slightly different concepts, but actually what strikes me is that even though there's all these different committees composed of different people coming up with the guidelines, they actually have a number of core principles that are very similar to one another. One of the really kind of bright lines is that arbitrators must not delegate their responsibility for final decision-making to AI systems. That is a bright line in every one of these guidelines. They also, pretty much all of them, impose an obligation on counsel and arbitrators to understand how AI systems work, and also to be cautious against putting sensitive information to AI systems that may result in an inadvertent disclosure. So it may be already known to many of the users, maybe the open-ended AI systems that you use on the internet, the prompts you put in and the information you put in can be used as training data. And effectively, that's a kind of disclosure. And in fact, there's case law out there about whether you put in what might be otherwise privileged information into an open system, is that a waiver of your privilege? And so to guard against those kinds of questions, everyone is admonished under these guidelines. Be sure, to be careful about what you do with data and what kinds of systems you put it in. So they do other things, but the bottom line here is that those soft law guidelines are really the ones that are leading the way on these issues. And I expect that even as we have a lot of fragmentation at the hard law level, and it's going to take a while for that dust to settle, we're already seeing quite a bit of uniformity and consensus among actual practitioners and arbitral institutions on how we should be using this technology.
Thank you, Denton, for this very valuable description of the hard law. I didn't know any of that actually, because, well, when we speak about AI, we mostly speak about the practical usage, right? So not a lot of people discuss this hard law versus soft law. And it's great to see that the US is so much ahead. So probably it will facilitate our use of AI as international lawyers. Okay, so the next prediction, I think that's an easy one, but you will explain. Cybersecurity precautions will be more important than ever.
Yes. So cybersecurity, let me start by saying it's already very important. It's very important to our clients who have sensitive business information, trade secrets, and other information that they would not want, widely disseminated. It's the reason why it's become very common in procedural order number 1 in cases, or whatever the number is, but to have something somewhere in the procedural orders to ensure that confidential information and privileged information is not being inadvertently disclosed, and not just inadvertently disclosed, but is being stored in systems that are potentially vulnerable to hackers and other malicious actors. So one of the ways that institutions protect against this is they'll use drop boxes or virtual data rooms that have digital security built into them to ensure that only authorized users can access that. That's one example. And many institutions discourage parties, and sometimes it ends up in the procedural orders, from emailing sensitive information, attaching to a brief. Be careful, what you attach to emails, because email systems, even though we have a lot of security around them, are not secure as many other alternative ways of transmitting and storing information. So cybersecurity has always been very important. But as I said, or as I predicted, I think it's going to be more important than ever, because as you many of us have probably heard in the news, the AI systems are getting so advanced that they're able to quickly find and exploit vulnerabilities in online data storage systems and online networks in a way that is actually truly terrifying. And so I think that means that parties and counsel need to get really smart about how are we going to, and really thoughtful about how are we going to save data. We need to make sure that the systems are at enterprise grade, enterprise level for security. We also make sure that we're only using enterprise grade AI systems, particularly closed-ended systems, so that if we're processing arbitration transmitted or received in the arbitration or from our client, that it's not being disseminated to these open-ended systems that are potentially disclosing information to AI companies or other actors. Another thing to think about with this is sort of adjacent to cybersecurity, not exactly cybersecurity, is I think parties are going to get more cautious about protecting against deep fakes, deep fake testimony when it's not live and present in the room. So over the internet, I presume something like this. And also deepfake documents, because it's really easy. You could probably use a number of AI systems now to manufacture, not just a contract, but a negotiation history for that contract, and emails back and forth, and post contract correspondence. And so think about how easy it is now to potentially manufacture evidence. And of course, the deep fakes, I think we're going to see we're going to have to be conscious about putting in measures to ensure that the witness on the other end of the camera is actually the witness.
Exactly.
Historically, this is why many tribunals actually would not accept remote testimony that's only audio, because we could never see the person. We thought that just seeing someone on camera was good enough to verify identity. I'm not so sure that's enough anymore, given the advancements in deepfake
That
technology.
could bring us back to the real hearings, you know, like going down in virtual remote hearings, and the fact that people will want to see real people.
Yes, certainly in certain cases.
In big cases,
yeah, I think it would. I think it would. I'm sure there's workarounds that we can do so we could still have virtual participation. But it's something you have to be conscious of now, because we're now in this era of AI.
Interesting.
So I think the bottom line is that all of us need to become more educated on the capabilities of AI, the vulnerabilities, and also we need to involve as much as possible where you have that resource, cybersecurity professionals on your team in the arbitration process, making sure you're doing everything in the right way that protects your client's data and the integrity of the process.
That's right. So prediction number 9, one of the favorite topics now.
I like this.
AI arbitrators will not be widely used to adjudicate international disputes, but they may be used in other ways.
Yes.
Which other ways?
Which other ways? Well, I'll get there. Let me start with the first part of that prediction. That there's been a lot of talk about the idea of an AI arbitrator, just submitting your case to an arbitrator, an AI system.
AI arbitrator, right, for smaller cases.
Exactly. So the vanguard of this is the AAA's AI arbitrator, which is really a system, and it comes with its own AI arbitration protocol, whereby it's only documents only cases right now. It's been trained specifically on construction arbitration cases, so it's most suitable for those arbitrations, and is most suitable for lower value cases. The AAA has developed this system whereby you can put up all your briefs, your arguments, your evidence. The AI arbitrator will assess that. It will give back to the parties sort of like a sanity check. Is this your arguments? Is this your evidence? Make sure it is. And then it'll turn around and start drafting up an award. Now, there is a human in the loop, an actual human arbitrator that AAA has trained to sort of supervise and ultimately issue the award. So it's still issued by a human actor. But you have the AI system, and also the human arbitrator will verify the award and make corrections that they deem necessary. They can intervene in the reasoning. But in the first instance, at least, it is the AI system coming up with the resolution or proposed resolution for the case. So we already know AI systems are capable of it. If you ask an AI system, not even the AAA's AI system, but just anyone on the market, even any of the public ones that are not specialized for legal use, if you upload documents and say, make me an award, it will do that. So it will do whatever you tell it to do.
And it will be neutral and independent.
It will be neutral and objective and all these things, right? But despite all of that, in international arbitration, particularly, I don't see AI arbitrators replacing human arbitrators even anytime soon or perhaps ever. At a technical level, actually, there is a problem. There's a reason that AAA only uses its arbitrator for smaller cases. And that's because the more data that gets ingested into an LLM system actually becomes harder and harder. It becomes like molasses trying to work through that and come up with sort of sensible, logical syntheses. And in other words, the systems begin to break down. Even our own systems that we use here at the firm, and I know at other firms, they limit how many documents you can upload. And frankly, international arbitrations, they're so voluminous in terms of all the witness statements. You still have hundreds of exhibits in many cases. Sometimes it could be a few submissions, all the way up to dozens of submissions. The idea that LLMs will be capable of running through all of that and coming up with sensible outputs, I think, really tests the limits of what these models can do now. Maybe later they can, maybe they
Mhm.
become more efficient, but where they stand right now, just the complexity and the volume of data in a case, I think it overwhelms current
I've
LLMs.
noticed that as well.
Yeah. So that's an issue. The other issue is, if you're still going to have live hearings, what is the AI going to do? We don't have, as of yet, any technology that allows the AI to sit there and observe a
Which
witness
is good.
and make, yeah,
We
probably
don't
a
want
good
it to
thing.
sit there.
Probably a good thing. But we don't have a system that can sit there and observe the witness and listen to the questions and intervene. But there, we don't have a system that can do that kind of interactive in-person process. So
Mhm.
how can we possibly, I mean, can you come up with workarounds? I'm sure you could. But I don't know if I want AI doing credibility determinations, right? That's
Mm.
just such a distinctly human thing to do. Is this person lying or are they not? Um, um, Also, I don't think LLMs ultimately are fit for purpose as arbitrators. They don't actually engage in any judgment or reasoning. As much as they look like they do, that's actually not what they're doing. They're essentially extremely advanced predictive tools.
Mhm.
And whatever biases are embedded into their data is part of the output that they give you back, but they're not doing their own judgment for the given case. Which brings you to another question I have. If you're giving your case to an AI system, which is programmed basically, is your right to be heard actually being respected? Is anyone hearing you? Embedded in the right to be heard is the idea that a human being is actually hearing you,
Mhm.
not just a system. And then finally, there's this, I think, legitimate questions around enforceability of an AI arbitrator generated award. Um, I have a colleague in London, Duncan Bagshaw, who was about to put out an article, maybe it's already released, but he gave me an early draft, where as one element of the article, he surveyed different legal systems around kind of the lex arbitri, in the United
Mhm.
States and France and the UK, other places. Every single legal regime assumes that the person rendering the award is a human being. None
Mhm.
of them have been adapted or updated to the idea of an AI arbitrator generating an output that can be legally binding in the same way as an award. So I think there would be a serious question about the enforceability of an AI generated award. Is that an award, even if no human being has authored and signed it? But I think in the end, no one really wants to entrust the resolution of a complex, important dispute to a computer. I think that's
That's
just a
right.
kind of a natural human instinct against it. And so I don't think, for all these reasons, I don't think AI arbitrators are going to be a big thing in international arbitration. With that said, and this is kind of the last part of my prediction, they may still be used in other ways.
Mhm.
And I think the chief way that they can be used is still for those case assessments. So like I said earlier, you can upload briefs, upload elements of a record into a system and ask it to assess the strengths and weaknesses of the case, maybe gaps in evidence and other things like that. So using AI systems sort of like a mock arbitrator to suggest to you kind of how strong is your case or where might there be gaps, what are the strengths. I think systems can even suggest, even reasonable settlement values being used more and more, deployed more and more mediations to that end. I think they will be used in those ways. In fact, going back to the AAA's arbitrator, they have kind of pivoted because at least last I heard, no one has yet used the
Oh.
AI arbitrator. That may have changed.
Mhm.
My data might be outdated. I need to ask someone over at the AAA about that. But they was released back in October, at least in spring. Still nobody had used it. But they pivoted now to offering the system to do case assessments.
Oh, that will be great, right?
That will be great. They still offer the
Mhm.
AI arbitrator, as far as I know.
Mhm.
But I think it's a demonstration that AI may not be replacing arbitrators, but they
Mhm.
may be assisting parties in understanding their case better.
Yeah. And the last prediction, which is very, very positive, international arbitration will continue to thrive in the era of AI.
Right. So I like to end on a positive note. So,
All do.
something that one of the things that drew me
Mhm.
into this field is that international arbitration is one of the most flexible and adaptive dispute resolution frameworks that I think are out there. Just remember how quickly international arbitration institutions and tribunals adapted during the era of COVID, and how we all sort of moved to taking up more virtual hearings, virtual presentation of witnesses, and we've adapted protocols for doing that. And in fact, the rules have now, many rules, institutional rules have been revised to give arbitrators that authority to conduct proceedings online when they deem appropriate. And then we're very good as a community at spreading knowledges about best practices around using virtual technologies for virtual hearings. I use that as an example because I think we're seeing today that that same kind of spirit of adaptability and forward-looking thinking and integration of new technologies is now happening with AI. For all the reasons we've been discussing here for the past, I don't know how many minutes, counsel and arbitrators are finding ever more ways of using AI, integrating it into their processes, and doing that not just for time savings and cost savings, but also when in skilled hands, it actually produces superior product. I think people are still going to remain very central to the process of international arbitration, with technology in support of everybody, practitioners, parties, arbitrators, experts, everybody along the way. And I actually think that international arbitration's embrace of AI, which is what I'm seeing, could make it even more attractive than it already is to, as compared with going to court, for instance, litigation, traditional court, because those forums that, this is not a criticism, sorry if there's any judges out there, but there's a lot of institutional inertia in state courts.
That's right. Everywhere, in every country.
Everywhere.
Every country I know.
And we're going to look like in our field, like we are just light years away. Like I said earlier, we're going to be in the Star Trek universe whereas everyone else is stuck back in the 20th century.
And I do think that the arbitration practitioners are brave people. Nobody goes to at least nobody I know went to the university saying, oh, I want to do arbitration. I didn't know about arbitration until I came to Paris 10 years after I started the studies, right? And so you did, as I know. Yes. So I think arbitration is for brave people, and brave people will not be afraid of using AI.
We are pioneers.
That's right. So let's see. We don't have any questions, and we're almost at the end of the hour, which is great. So I'm passing to my favorite question. So what are your favorite restaurants in Houston where you will bring your friends or people from outside?
Absolutely. And I do that with all the recommendations I'm going to come up with here. So first, it's not a restaurant, but a group of restaurants. But I think any Hugo Ortega restaurant is
that's the
wonderful.
One I've never heard about.
So you probably have. So Hugo's, Caracol.
Oh, Caracol.
Yes.
I know Caracol.
You know Caracol.
Yes.
And actually now in the base of our building, we have a Hugo Ortega restaurant called Zaranda, which is really excellent. I think any of his restaurants are just fabulous. So what he's known for is bringing really traditional Mexican, like not Tex-Mex, but Mexican flavors and cuisines and dishes. Many of them quite traditional, many of them quite innovative. I think any of those restaurants I just mentioned, they're wonderful, especially for people who maybe don't have as much exposure to go down to Mexico very often. You can feel like you're in Mexico, like you're in Mexico City and eating in any of those restaurants. And they're really, truly excellent. The service is good, the drinks are good. So any Hugo Ortega restaurant is number one.
Right.
Number two, Malish Szechuan Bistro. You know Malish Szechuan? It's a
No, I don't know what I did 5 years in Houston. I don't.
That's fair. They have a few locations now. I believe they started in Westheimer. Now have one close to my house on Shepherd, and have one in other places.
Don't disclose your address.
No. Well, it's a lot of people live around Shepherd. But it's a Szechuan Chinese restaurant with very spicy, very bold flavors. And you can dine in there, you can take out, you can order on Uber Eats, but I think it's some of the best Chinese food I've had anywhere. So Malish Szechuan Bistro for the Chinese food lovers. And finally, my third pick is Kata Robata.
I've heard about this one.
Yeah.
Never been.
So it's a Japanese restaurant specializing in sushi, has a lot of traditional dense dishes as well as sort of more kind of novel, contemporary dishes. There's a lot of great sushi places in Houston, but I really appreciate sort of the focus on tradition, quality at Kata Robata. And it's been around now, probably may have even been around when I was here at Rice. I'd have to go check that, which the longevity of a restaurant, I think a lot of times is a sign of its quality. So Kata Robata, if you like sushi, if you like Japanese, is my pick.
Great. Thank you so much, Denton.
Thank you.
Oh, we have questions. Oh, la la. Okay. So, anonymous attendee. For Mr. Nichols, in the way you are using AI or recommending more junior lawyers to use it, do you have any resources of best practices for the young generation looking to use AI responsibly to improve their own output?
That's a wonderful question.
Sure, I am happy we were helpful.
So this is going to sound a little bit glib, but I'm going to be completely serious. Why don't you ask AI? It can actually give you some wonderful ideas for how its system can be used, and others have been using it. So I would actually, even ask the system. But beyond that, I think a great way to learn about how practitioners are using it is to tune in to programs like this. In Houston, we are blessed to have a wonderful international arbitration community, and we have conferences and workshops coming through town. I'm a director of the Houston International Arbitration Club, where we put on talks. We just had one earlier this month with Doak Bishop, who formerly led King of Spalding's practice, who talked about his view on how AI is being used in international arbitration. So that's a long way of saying get really plugged in to the international arbitration community, show up at events, tune into events, and I think you'll find all sorts of use cases that were not obvious to you, become apparent, and you'll learn through that process.
Thank you, Denton. And we have a question or comment from Richard Dirch. Prediction on AI-related topic. Data centers will be the next wave of international arbitrations. Huge infrastructure projects touch on numerous issues which are central to arbitrations. Kata rules. I don't know. Do you know what's Kata rules?
I think you meant Kata Robata rules. My third restaurant pick. But going back to Rich's earlier.
Oh my God.
No, I think that's really interesting and forward thinking. There is a big boom right now, not just in the United States, but in other countries, including Canada, which has a lot of energy resources. And let me say that data centers, they need a lot of things, but the one thing they really need is energy. And that's why a lot of people don't realize that Houston is really at the center of the AI boom. Yes, out in California and Silicon Valley, they're developing the actual code that is the LLM, but here in Houston, we are thinking of how do we actually power the data centers that are going to need massive quantities of energy, especially if we're going to meet the projections that we have for its adoption and uptake. So I agree with Rich that we're going to see, I think, a lot of not just big disputes, but mega disputes. Many of these data centers, there's some that are going to be as big as Lower Manhattan. Huge infrastructure projects, and they're going to be centered largely around areas where they have access to cheap energy. And so I think so that could be here in the US. Of course, we have abundant energy resources, the shale gas for sure, which is powering data centers as we speak, but other resources as well. So I think that's a pretty safe prediction that Rich has made, and I.
So
agree with
we had 11 predictions, which is great.
that. Yeah, he can have the 11th, but yes.
Okay, maybe he will be our next guest, who knows, with a different topic though. So then, thank you so much. That was very, very valuable. And that was the first discussion of AI, which I've heard, which went so much into the substance. And I learned a lot. I'm sure our audience learned a lot. So it will be on YouTube channel of Houston Place of Arbitration, also as a podcast. If you want to share that with your friends, Denton will be with you on the go. Thank you so much.
Thank you, Daria.